about how exciting contracts are. I used to work with an older lawyer, and when he would get really excited when we'd sue somebody, and he'd say, "It's going to be a hot time in the old town tonight." So here's for that for contracts. Being sarcastic, okay. All right, trying to put you to sleep before we get in. But the stuff is important, all right? It may not be a rip-roaring exciting time, but it is important. So we talked last time about forming contracts, what you have to do to form a contract, what an agreement looks like, what an offer looks like, what a rejection of an offer looks like. And everything that we talked about was mostly geared toward making these contracts and fulfilling them. Now, human nature being what it is, sometimes things don't go exactly as planned, okay? And that's, unfortunately, probably going to happen to you someday with a contract. Whether it's a contract for some kind of home repair or home improvement, whether it's an employment contract, somebody is going to breach an agreement with you at some point. And so I think you need to know a little bit about what that looks like, what could happen, and what your rights are. And there may be a time when you're in an agreement that has become untenable, and you want to know what are your rights to possibly leave that agreement. Or if you have to breach it, what kind of risk exposure do you have? So this is a very, very large part of my law practice, is talking about contracts, drafting contracts, saying, what do we need to do to get in? What would we need to do to get out? What if somebody leaves us high and dry? What provisions do we make? Okay? So there's a lot of strategy, actually, that goes into these things. A breach of contract is when one or both of the parties don't carry out their obligations under the contract. The promises that they made to the other party. And when there is a breach, oftentimes the law will provide some kind of remedy. Okay? So we have this dispute resolution system of the courts. It's not the greatest thing in the world, but it beats the older way a lot of times. And we do allow private agreements between private parties to be enforced through the court system when they've done everything right. So everything that we talked about in part one, when they've set up the contract correctly and somebody breaches it, then you can go into court and say, hey, I need a remedy here, okay? And we'll talk about the different kind of remedies that are available. But if you should have to go in front of a judge or a jury or both for a breach of contract, we look at, is the contract enforceable? So that's that part one stuff. Did we do everything that needed to be there? Have the parties performed their obligations under the contract? Is it a material breach? In other words, is it a big enough deal that we should get the court involved and can get the court involved? And even if there is a breach, is there some excuse for it, some kind of defense? All right? So what could make a contract enforceable or unenforceable? Well, all those things that we talked about in part one. Agreement, consideration, capacity, legality. Those things have to be there in the affirmative, and they have to be present and accounted for, all right? So remember our four little pictures. If you go to court to try to enforce a contract against somebody, you've got to show, first of all, that there was a contract, and then second of all, the burden is on you to prove up the elements of that contract and that everything was done correctly, that it wasn't somehow defective in a way that makes it unenforceable, okay? We say there has to be a meeting of the minds or a voluntary consent or assent to the contract having been created, that the people agreed on the important parts of the contract. I'll talk a couple cases to show you exceptions to that makes it sometimes sound a little bit that's more tricky than it is. It's a pretty low bar. I mean, were you essentially bargaining for the same things and you basically understood it, okay? What could cause a contract to lack that kind of meeting of the minds or that voluntary consent? Sometimes mistake. Big emphasis on the sometimes, because I'm going to show you that courts are not always real eager to jump in when it's a minor mistake or when only one party has made a mistake. Fraud, if you lie to somebody to get them to enter in a contract with you, that's probably going to make it unenforceable. Misrepresentation is a flavor of lying to someone. It's a little bit lower bar than fraud. Undue influence or duress also. We'll talk about some examples of these. The contract's got to be in the proper format. So I told you, you might have a written contract or you might have an oral contract, but remember there are certain contracts that have to be in writing. So the biggies that we talked about were like real estate, sale of goods over $500, and a contract that takes longer than a year to perform. There were some old-timey additional ones there that I don't think you have to worry about. And then you have to make sure there's no extraneous elements in this contract that make it void or unenforceable. In other words, you haven't put in any illegal subject matter. Okay? We'll talk more about that too. So a great example of contract provisions being limited by law would be the Iowa Landlord and Tenant law. All right, if you're interested in this, it's Iowa Code Chapter 562A. And you can go and download this, and it's, 10 or 15 pages. Not very long as the law goes, but it sets out all the rules for renters and landlords in Iowa. And it sets out the rules for a lease contract that you can have with your landlord. And although many landlords apparently didn't get the memo or chose to ignore the memo, you cannot contract around these provisions in the law. In fact, they were put there specifically because landlords were abusing tenants. All right? So this code chapter says they can only charge up to 2 months of rent for a damage deposit. Okay? And there are very specific rules about when they have to return that to you and when they have to give you notice if they are not going to return all or part of it to you. And if they breach those elements, then you're entitled to some compensation. It outlaws the shifting of attorney's fees to tenants. So many of you guys have probably signed leases that says something like, in the event that tenant is late on rent, there will be a $500 penalty per day that it's late, and the tenant will pay the full amount of attorney's fees for collections against them, right? I mean, maybe $500 a day is a little bit of exaggeration, but we're talking Iowa City here, right? So maybe not. It's illegal to do that. And yet, many landlords in Iowa City still put that in there because they count on your ignorance to not know that and not enforce that against them. I don't mean ignorance in a negative way. You probably don't go reading the Iowa Code just for fun, so why would you know this otherwise, right? But they prey on students. They limit the rules a landlord can create about the use and the occupancy of the premises. Okay, so it tells you what they can and cannot do, when they can enter your apartment, when they can't. So I used to rent a house on campus with 6 of my friends, and we had a landlord who was pretty crazy. He's still around in renting, so I'm not going to use his name. I like him. He was a funny guy. But one morning I woke up. I had a calculus final, I think, that morning, and I got up and I was trying to leave my room, which is in the basement, at about 7:30 a.m. It was like an 8 o'clock test. And I opened the door to my room, and the washer and dryer were outside my room, where they normally were. Now I saw nothing but wet concrete for the whole hallway, and my landlord standing down there. And that was the only exit I said, Jim, because that was his name, what are you doing? And he's like, oh, I poured a new concrete pad to put the washer and dryer on. And I'm like, well, I need to get to my exam. And he's like, well, you can't come out this way. And I said, there is no other way. He's like, you better crawl out the window. So I did. Yeah, I didn't bust him on that. He was a pretty good guy for other things, but, you know, there was no warning or anything. So the things you do. Okay. So I do like to make fun of Iowa City landlords a little bit because they get away with murder. So you've got an agreement, and you want to figure out if it's enforceable. I can kind of think of 4 different categories you can visualize your agreement in. Okay. Now, if you've done essentially everything right in the drafting and the signing or executing of the agreement, you're going to be up here in this green square. Everything's good. All right. I don't like the phrase airtight contract. Sometimes my clients say, draft me an airtight contract on this. It's like, dude, there is no writing known to humankind that someone cannot try to weasel out of. Okay, but if you've done everything by the book and by the law, and you have genuine consent, the other party is old enough, and they're mentally competent, and everything is sort of hitting on all cylinders, then you're up here. You can enforce that contract. Okay, and if your partner, the person with whom you've made the agreement, if they breach that contract, then you can go to court and hopefully successfully enforce it against them. Now, these other 3 quadrants, you're in a little bit of trouble if you need to enforce it. Doesn't mean that the deal cannot go forward, but if you would have to seek the court's assistance in enforcing it, you might not get their assistance if you're in one of these other quadrants, okay? So the yellow quadrant up here in the upper left, this is where a contract is voidable, okay? It's legally valid in terms of the subject matter, but there's something wrong with the capacity of one of the parties. So I gave you the example of my 17-year-old farm neighbor buying a truck on payments from a dealership, okay? Can he do that? He did that, all right? If he wants to keep making the payments and the dealer wants to accept them and eventually he pays it off and no one ever breaches, then that worked out fine. But what if he doesn't make the payments and then the dealer tries to enforce an action for breach of contract? He can say, look, I was only 17. You have to be 18 to sign a contract in Iowa and have it enforced against you. No, this is voidable, and in fact, I'm exercising my right to void it right now. Now remember, he'd have to give back the truck. There would be some kind of restitution calculation. Okay, it's not a get-out-of-jail-free card, if you will, but it's voidable. Down here, you have not got any potential for enforcing the contract in court. All right, so if you have a void contract, like you did a written purchase order with your drug dealer to purchase a bunch of cocaine, all right, and you don't get the quality or the quantity you want or whatever. I'm not familiar with those kind of contracts. Never written one, thankfully. But if somebody breaches, the court's not going to help you here. All right? It's illegal subject matter. That doesn't mean people haven't tried. Okay? Every now and then you will see courts reject a petition against someone's drug dealer. An unenforceable contract is a contract that has become void and unenforceable because of some change in the law. So suppose you had a contract to buy some kind of nutritional supplement, and then it turns out, as it often does, that it's a potentially dangerous chemical or herb or whatever, and the government says, this is outlawed. You can no longer buy whatever, synthetic whatever in the U.S., okay? And then it becomes unenforceable. So down here, Court is not going to help you. Here is iffy. Here, you're in pretty good shape. So obviously that's where you want to be, is in the upper right. Now, what kind of problems can creep in, and how would a court deal with them? We've got a really famous case about cows. And I've learned more about this because, number one, I now own 4 cows, which is pretty exciting. But also I had a student who was in 4-H, and he told me the proper terminology. So actually, this case, which is about the animal that you might commonly know as a cow, but specifically it's about a heifer. Anybody know the difference between a cow and a heifer? A couple people. All right, you guys did 4-H. So a heifer is a female cow that's never had a baby. All right, that's the technical term. And we go back to 1887 in the state of Michigan, and you've got these 2 guys, Sherwood and Walker, and they are interested. I don't remember who sold who the cow. The case is in your book, whether it was Sherwood or it was Walker. But basically, there was a heifer. It had never had a baby. The owner of it had attempted to breed the cow and have cow babies, calves, right? And it had never happened. And so the owner was under the belief that this cow was barren. In other words, it was not able to reproduce. Okay? And so he was going to sell it to this other fella. And he said, look, this is a barren cow. You know, you can use it for whatever. I don't know, can mow your lawn. But you can't, you're not going to get any calves out of this cow. And the other guy says, okay, you know, I understand. I'll buy it. And I think it was like $40 was the sale price. Granted, this is a long time ago, but still pretty cheap. Okay? Well, the purchaser gets the cow, puts it out with the bull, and lo and behold, cow has a baby cow. All right, a calf, yes. So the first guy, the seller, says, well, I really undercharged you for that. That's, you know, that was way too cheap, you know, for a cow that's now is a cow, not a heifer, for a cow that's capable of having calves. And the second guy said, well, too bad, I got an awesome deal. Well, first guy takes him to court, and the court looks at it, and they said, this is a case of mutual mistake. Purchaser thought he was buying a barren heifer. Seller thought he was selling a barren heifer. Turns out it's a cow that's capable of having calves. So he said, you get the cow back, you get the $40 back. I'm going to put you back where you were before the deal took place. Okay? So that's a case of mutual mistake. The parties made the contract based on a really important factual error. And they both negotiate based on the same factual error. It doesn't usually go that way of unwinding the transaction. So sometimes people buy land and they later find out it's got an oil well on it or a mineral deposit that's worth a lot of money or something like that. The courts don't usually unwind those transactions. All right? It's pretty rare, and of course, the plaintiff's got the burden of proof on this one. Unilateral mistake. So what if only one person makes a mistake? So I'm selling you this big rock, and you think, that's a gold nugget. Amazing. You say, how much is it? And I say, $4,000. You think, that's a great deal. You know, gold is selling for whatever, $1,000 an ounce. I'm going to make a lot of money. So you purchase it. You come to find out that is a much more common mineral called iron pyrite, aka fool's gold. So you go to court and you try to rescind the contract saying, I thought I was buying actual gold. Is the court going to help you? Probably not. Okay? When one party goes in under a mistaken assumption, it's a unilateral mistake, and in general, you're out of luck. Okay? If you are going to win a case of unilateral mistake, you have to show you entered the contract based on a really basic factual error, and either it would be totally unconscionable to enforce the contract, or the non-mistaken party knew about the false assumption. Okay? Now, what am I going to testify when you go in and say, I thought it was gold? I'm going to say, I never told you what it was. I didn't know you thought it was gold, and I certainly never said it was gold. Tough luck, right? So, unless there is some kind of, fraud, inducement, or we reach the standard of unconscionability, which is very, very, very high, the court's not going to unwind it, okay? Because the court doesn't care if you make a crappy deal. They will look very closely at the elements of the contract and see if it complies with the law, but they don't care if you just overpay for something or if you don't get enough money for what you're selling. That's not what the court is there for. Undue influence and duress. You are not allowed to force someone into a contract. And if you do force someone into a contract, then that contract will later be unenforceable. Okay? People have to voluntarily consent to entering into the agreement with you. All right? If you put a gun to someone's head, saying, I'm going to shoot you if you don't do this, they're going to sign the contract. Later on, if you try to bring an action to enforce that, and that person can show as a defense that they were forced into it or intimidated into it, you're not going to be able to enforce that. All right? Now, there's a difference between forcing someone into a contract and simply taking advantage of a person's sort of lack of care, if you will. So one of the examples that is really common to illustrate this is the idea of a gas station out in the desert. Now, we're pretty lucky in Iowa. Every small town has a Casey's in it, right? You're not likely to run out of gas driving around Iowa, even in the most rural parts of the state. But you get down into the Southwest, and there are towns and gas stations maybe hundreds of miles in between. So suppose you're out there in the desert, and you're on the very last bit of your tank, and you cruise into a little town, and there's one gas station, and it's got a sign, next service 100 miles. And your thing is showing the warning light, so you know you've got 30 or less. And you go in, you go to the attendant and say, I'm interested in getting some gas. I'm afraid to ask, what does it cost? He says $100 a gallon. Okay, I'll put it on my credit card. I don't really have a choice, right? Because I got to get to the next town. So suppose later you were somehow to dispute that on a theory of contract, and you say it was duress. Actually not. You were the one who cruised into that town with only a little bit of gas in your tank. They didn't make you fill up. You could have, moved there, stayed there, whatever. So it's important to think about the difference between actively forcing someone into a contract and simply taking advantage of their stupidity or lack of care or situation. Now, ethically, that last one's a problem. But legally, it's going to be enforceable. Now, what about looking at whether both parties have performed their obligations? So if you're going to go into the court and try to enforce a contract against somebody, one of the things that you're going to have to show is that you did your part. You complied with the contract as far as you could on your end. Because if you're going to ask for relief, you got to show, well, I did my part. Now I'm asking you to make them do theirs or compensate me for not doing it. Okay? So most contracts are discharged by performance. People do what they say they're going to do, and the contract is fulfilled, and the parties go on about their business. Okay? If somebody doesn't do what they said they would, or if the other side thinks they haven't, Then you get into this analysis of how much performance did they do. So there are some contracts that require complete or strict performance, okay? Performance that is exactly what is promised, and failure to do so is going to be essentially fatal to the essence of the deal. Now, this is not really a common kind of thing in contracts. We lean more toward this substantial performance standard that we'll talk about in a second, but sometimes there might be a good reason that you would put into a contract that you've got to perform all of the duties in there in a certain way. So imagine a professional athlete, okay, and they sign a contract to play in all of the team's games, if assuming the coach puts them in, including the playoffs. Because what if you played all season and then you got down to the championship game and the player just didn't show up? Well, that's kind of like the most important game of the year, right? I think that would be a case where strict performance is required. If I taught this class for 15, 16 weeks and just didn't show up for the final exam, didn't bring it, you guys probably be happy about that, but the university would be less so, okay? So there's some cases where you've got to do everything to the letter. More often the court is going to look at, did you do substantially everything that was expected of you? And if you didn't, maybe there's some set-off. So I think there's an example in your book of a guy hires a builder to build his house. Say it's a $300,000 house, and all the work is done except minor punch list kind of details, like there's a few missing doorknobs, you know. And so the guy who had the house built for him says, sorry, it's not perfect, I'm not paying you anything. Would that be okay? Probably not. The court's going to say, the builder has substantially performed, you can pay him or her $300,000 minus the cost of the doorknobs, all right? Now, what if you don't even reach the substantial performance? Let's see, you do a little bit of the job and then abandon it. Well, maybe you recover the value of your work. Bear in mind there are going to be a lot of costs associated with the other side. Maybe hiring someone to do what you didn't do, it may wipe out the value of it. So it's going to be very hard for somebody who only performs a little bit of a contract and then breaches to enforce an action for that amount of payment. You've also got to show that there's a material breach, okay? When you're seeking to enforce a contract against somebody else. What is a material breach? Well, this is something that you can kind of argue around and around. And some folks will try to write it into the contract. So I was negotiating something for one of my clients, and we were dealing with a very large company or group of companies on the other side. And when you deal with really large companies, they tend to take an attitude of, here's our contract, take it or leave it, we're not going to deal with you. And so they had a little thing written in the contract saying that any breach of this agreement, no matter how small, shall constitute a material breach. And I talked to their general counsel and I said, that's not really the law. And he was like, well, what do you know about the law? I don't know, law professor. Other than that, not much, I guess. I said, why don't we, maybe look for a generally accepted definition of material breach, or why don't we spell out the specific things, and so we were able to kind of spell that out. But a lot of times the court is going to have to decide this because you may not have it spelled out in the agreement. And so they're going to look at it and say if it substantially harms the innocent party, it's a material breach. What substantially harm? Those are the fighting words. That's what your lawyers are going to get to argue in court. Sometimes that's going to be obvious, like the builder built my whole house except the roof, and now it's been raining in for days. Sometimes they're not so obvious. All right. Now, what about when you're in a contract with somebody and you think or know that they're going to breach? They haven't yet, but it looks very, very clear. So suppose you make an agreement with a builder to build you, let's say you're the university, and you make a contract with a builder to put in new luxury boxes in Kinnick Stadium, and they have to be in there by the start of the football season, which is, September usually. And suppose by August 15th, they still haven't showed up or made any progress on it. Do you have to wait until the first football game to sue that builder for breach? No. When the other side makes it unmistakably clear they're not going to honor the contract, you are discharged from performing, and you get to sue them for breach. All right? Now, of course, you have to prove this, and, what are you going to say? Well, it's 4 weeks until the football season. They haven't done any work. We needed to hire somebody else to get this started. They're going to say, we had 4 weeks. We could have done it, right? And then they get to fight about it in court. But those things happen. The idea is, unlike a lot of other kinds of law, you don't have to wait until the actual damage comes, but it has to be very clear that it is the breach and the damage will come. Now, before you sue, is there a legal excuse for the breach? So remember, with torts, we talked about, are there defenses? Product liability, are there defenses? So you got to think about this. I kind of love the WikiHow funny clip art. I don't know who draws them, but this is from How to File a Lawsuit. This guy's thinking about a ripped contract, a man in a suit, and a gavel. So I just love it. So what excuses might somebody have against a breach of contract suit? Well, number one, you could say, you didn't perform either. All right? That can be an excuse. If somebody is going to sue you for breach of contract, maybe they haven't performed either. So take the example of the university and the luxury boxes. The contractor could say, well, you never made the deposit. You never gave us the blueprints we needed. Whatever. You could say, well, there's a breach there too. You can say, there was no contract. All right? Plaintiff has to plead the existence of a contract and whether it's written or an oral contract. And I've had the situation where I've had people threaten to sue clients for breach of contract. And I said, okay, send me over the contract. Well, we were talking about it. Talking about it is not a contract. All right? Improper format. So if it was a contract that had to be in writing and it wasn't, so you go sue someone because you made an oral contract for them to buy your house. The court is going to say, there's no such thing as an enforceable oral contract to buy real estate. Sorry, you're out of luck. Unconscionability or duress, as we talked about. Excuse me. Defendant discharged from performance by operation of law. I'll show you in a minute. Or the contract may have been modified or discharged by a subsequent agreement. Discharged by operation of law. So this is when the subject matter that the contract deals with somehow changes or gets screwed up. All right? Suppose you had contracted with somebody to buy this car, this Audi. All right? This is a picture of a car that's been hit by lightning. Pretty exciting. Suppose you were going to buy that particular car from a private seller who only owned one car, and that was the car that you wanted. And you made a contract, and you'd put some money down, and the day you came to pick it up, they said, I'm really sorry, it was out on the street, it got hit by lightning. You say, I don't want that. That doesn't look like it will drive. They say, here's your deposit back, I'm sorry. Do you get to sue them for breach? No. Okay, that wasn't their doing. That's kind of a impossibility of performance. They can't give to you the car that you wanted to buy because it's changed. The lightning changed it. Frustration of purpose. So maybe you want to see a Mardi Gras parade, for instance. So you rent somebody's apartment through Airbnb that's on the parade route, and you spend a premium for that. And then, as it turns out, you find out a few days beforehand that they've changed the parade route, and now you're not going to be able to see it from there. Are you still on the hook for that? I don't know Airbnb's specific legal agreements, but in general, the court would probably say, no, the whole purpose of it was to see the parade. The parade is no longer going to be there, so you're off the hook. Okay? And bankruptcy is another one. So if you are in a contract with someone, like maybe you're buying a car on payments, and you declare bankruptcy, and you declare that as one of your debts, the court is going to wipe out that contractual agreement if that's put into the bankruptcy and you disclose everything and go through it. So those are ways that it could be discharged by operation of law. There's also this thing called force majeure. You might see it as acts of God clause. Sometimes if you ever look closely at an insurance policy, especially like event insurance or anything that has to do, maybe if you buy tickets for a concert, particularly like an outdoor concert, you might have a bunch of stuff that you have to click through on Ticketmaster, and it's probably got a force majeure clause, which says like if there's a tornado that day, if there's a riot, if there's flood, earthquake, storm, hurricane, war, invasion, civil war, rebellion, usurped power, right? Somebody goes Game of Thrones on your concert. The performers aren't going to show up for that, right? And you'll get your money back for the ticket. But you don't get to sue Ticketmaster because you didn't get to see whoever, right? Sometimes people will make other arrangements, subsequent agreements after the original contract. And you can do that, all right? Maybe you agree to cancel the contract, and as long as both sides are okay with that, you can do that. Novation, that's where you take one contract and end it and put a new one in its place. If you've ever sublet your apartment in the summer to somebody else, a lot of times your landlord is going to ask you to do a novation, which is where you sign something concluding your lease, and the new person signs something starting a new lease that is a contract specifically between them and the landlord, so that it's not actually a true sublet where they're leasing from you, standing in the shoes of the landlord, but they actually create privity of contract between them and the landlord. So that's a novation. A settlement agreement, like in a lawsuit. Suppose you've got an employment contract, and then you're discriminated against unjustly because of your race or your gender or something. You sue your employer, and the whole thing is subject to a settlement agreement. You might write in there, in exchange for this sum of money, whatever, this employment agreement is no longer in force. Accord and satisfaction. So this is where you offer to pay a partial amount of your obligation in order to end the contract early. So I think like DirecTV is a great example of this. They're one of the most awful companies to deal with in terms of contract. You get like a year where it's like $10 a month, and then the next year it's like $200 a month, but they only offer the 2-year contract. And you can get out of that early if you want. You just have to pay a very low cancellation fee of like $400, right? That's kind of an accord and satisfaction kind of deal. Or you could offer something to end that early. So remedies and damages, kind of talking about the same thing. If we want to be really precise in our definition, the damages are what the actual damage that somebody causes to you by breaching a contract, and then the remedy is what the court can give you in response to your lawsuit to try to fix the damage. The words are often used interchangeably. So you might hear somebody say, well, the court awarded X amount in compensatory damages, okay? Damages is more what you ask for, remedies is what you get. But we pretty much talk about them interchangeably, okay? Remedy is probably the more proper word to use, okay? But let's talk about these different things. Now, what can you get? What can the court give you, and what can they not give you? All right? Compensatory damages, sometimes they're called make-whole damages, because the intent is to put you back where you were before the other party breached the contract. And when I say put you back where you were, we're usually talking financially, all right? So what is your actual financial loss? And if things go well, the court is going to order the other side to pay that, all right? So if you are the owner of these goods, you paid this trucking company to ship them, and this happened, and suppose there was no insurance involved, all right? Compensatory damages, those goods appear to me to be ruined, so the company is going to have to pay you for the value of those goods that they dumped out the side of the truck, all right? So that's kind of the most basic level. You're always going to be asking for some level of compensatory damages. From there, you may be able to get some additional categories of damages. And when these are available is often a question of common law, case law, all right? But consequential damages is something that you would think about a lot in business cases. And that's the lost profit due to a breach. So lost profit is a little bit different than the loss of the goods. So here, compensatory damages is the stuff that fell out of the truck and got damaged, your inventory, in other words. So first thing you'd ask the court for is the value of that inventory. But that shipping company was probably shipping it somewhere because you had sold it to a customer. And you were going to get more money than the inventory cost, right? You had some profit built in. And now you're not able to do that because they didn't ship it to the customer. They dumped it on the side of the road. Okay, so you ask for consequential damages for the lost profit. And if you've done everything right, you should be entitled to receive that. Now, beyond that, in contract, things get very, very, very difficult, okay? These are kind of the two normal things that you ask for and can receive. This other stuff gets pretty dicey, okay? So the first one, nominal damages of $1. This is kind of the court saying, okay, you proved breach of contract, but we can't find any reason to award you any substantial amount of damages. You proved a breach. We're going to give you $1 because you're right, but there was no other damage. This happens sometimes. I don't think people usually bring a case asking for $1 in damages. They're probably asking for a lot more. The court finds sort of a technical breach of contract, but they say that you just weren't really hurt by this, okay? So it's not a great situation to be in if you're the plaintiff. Incidental damages. Here's where you've got to go out and show, okay, I lost maybe the value of the inventory, I lost the profit that I would have got, and I incurred these other things too. Like I had to pay somebody to go pick up the broken goods from the side of the road and store them because they're evidence for this case, and I've had to store them for 12 months at $100 a month, all right? So incidental damages is kind of the other stuff that can get dragged along with it. We don't really get into punitive damages in contracts. We talked about punitive damages in tort and maybe a little bit in product liability. And these are when a judge or a jury says, you know what, the defendant was so out of line here, they were so outrageous that we have to send a message. We're going to put a large damage amount to punish them so that they don't do this again, and so that other companies or people see this and they don't repeat the error. All right? That doesn't really play in contracts. All right? That plays in stuff like the boiling hot coffee on somebody's legs, the terrible product liability, the product that explodes and kills people. All right, the private bargains that you make tends not to get people all that upset or excited, and so generally we don't have a punitive damage remedy for contracts or breach of contract. Sometimes clever folks will try to get around that through the use of liquidated damages. And this is really just an attempt to write punitive damages into a contract. Sometimes the courts will enforce these, sometimes they won't. All right, so this is an excerpt from our football coach's an earlier contract he signed. I haven't looked at the recent one, but I believe there is a similar provision in there, which is basically he's got a contract, an employment contract, that's guaranteed for a term of years. And if the university fires him before that contract is up, we have to pay him 75% of that amount. Maybe now it's 100%, I'm not sure. But we have to pay him basically as if he were here coaching, even though we fired him. That is a liquidated damages provision, okay, where they put in a certain amount that is basically a penalty. Now here, it's also a little bit of insurance for him. He's saying, why should I sign a 15-year contract with you guys when I might make more at a different school? Well, okay, we're going to guarantee it for this many years. So in this case, a very specialized high-stakes contract, the court would probably uphold that. But I'll give you another example of where it's really not appropriate. So I used to paint houses as a franchisee of College Pro Painters, and we had to submit all of our jobs that we did to the company, and I paid a royalty as a franchisee. Now, they knew that some franchisees were dishonest, and they would do jobs off the books to avoid paying that royalty. So they put in a provision that said, if we catch you doing a job off the books, there will be a liquidated damages penalty of $25,000 per house that you paint. Can you imagine a big multinational company suing a college kid for $25,000 times how many houses? No, probably not going to happen, okay? Sometimes you will see people put these provisions into an agreement just to intimidate the other side into compliance. It's not good practice because the court may look at that and say, illegal. With a contract, if the other side has damaged you through their breach, you do have to try to mitigate, or you may hear the word cover, your damages. All right? So this is really a defense that the other side can use if you don't do it. They can say, yeah, I screwed up, I breached, but they made no attempt to mitigate. So suppose you have a contract for somebody to install the sound and lights for a big concert, and they don't do it. And then you don't try to find anybody else to do it, even though there are other professionals available. And the concert is a bust, and you lose millions of dollars, right? And you go and you try to sue the light and sound guy, and they say, well, look, you didn't even attempt to mitigate things, right? So you do have to try to mitigate it. Now, what about equitable remedies? Because we talked about injunctions, injunctive relief, equitable remedies, all in that same category. And this is where the court, specifically the judge, tells somebody to do or stop doing something. All right? Can you force somebody to comply with the terms of a contract instead of money damages? It depends, okay? Generally, money damages are going to be your remedy. We don't force performance of any personal service contract because that is involuntary servitude. All right, and that's prohibited under the 13th Amendment of slavery, anti-slavery. So I had a contract come across my desk for one of my athlete clients to do personal appearances. And it is going to make X amount of thousands of dollars per appearance. And the contract was from another country, so I'm hoping that excuses the poor drafting. But it said, first of all, strict performance is required. And second of all, it said there will be specific performance. The person, if they sign up for these dates, they have to be there no matter what. Okay? And the court can enforce strict performance. And I sent it back and I said, I'm sorry, in the U.S. we have this little thing called the 13th Amendment that says you can't force people to do labor. All right? Doesn't matter if it's paid or not. You cannot enforce a personal services contract through specific performance. Okay? Where can a court order specific performance? Sometimes it happens with the sale of land. Or maybe an antique, or like a collector's item, or a collector's car, some kind of one-of-a-kind thing. So you make a contract with somebody to buy, a baseball card, a specific one in a specific condition, and they decide, I don't want to sell you that. So then you might be able to ask for specific performance. So ask the court to tell them, yeah, you have to sell that at that price. You made that deal. One of the cases I put in the optional reading dealt with this. So we defended an older lady here in Johnson County who had a farm, and a less than reputable buyer tricked her sort of into signing a contract to sell it for way less than it was worth. And when she got some better advice and said, I don't want to lose my farm, I don't want to lose my animals that I have here, I don't want to move, he said, okay, I'm going to sue you, and the court is going to force you to move. And we won at trial, and we won on appeal, okay? Because specific performance is an extraordinary remedy. And if you want this, you have to do everything right on your side. It's called the doctrine of clean hands, okay? So in other words, if you're going to try to force someone through the courts to do something specific, like sell them your piece of land where you live, you have to do everything right. And the potential buyer had not done everything right. He blew a bunch of deadlines. He screwed up on the paperwork. Okay, so we were able to win that one, which was a good thing. Injunction, this can come out of a contract in order to do or stop doing something. So maybe you have a contract that is a non-compete agreement, and you have an employee and they've signed something that says for a period of 1 year after leaving this job, I will not engage in this business in a 5-mile radius, for 1 year. And then they leave, and then they go start up their own business that directly competes with yours, and you go to the court and say, we want to enforce this. In that case, the court may enter an injunction saying, you have to stop being in this line of business here. All right? In the court's equitable powers, which is just sort of their inherent power to do judge-like things, equitable things, in other words, kind of balancing the scales of justice, the court might be able to rescind or reconstitute a contract a little bit or reform it. So a court, in certain cases, can have the inherent powers to either say, this contract is totally against public policy, it's totally anti-competitive, it's void for these reasons, and essentially wipe it out. Or in limited circumstances, they might go through and change some of the terms of it. All right? So sometimes it's called blue lining. I guess maybe judges used blue pens back then. It's all computerized now. But they might rewrite a contract. So, one example would be like from the Landlord Tenant Act. If they find a rental agreement is unconscionable when made, the court could either refuse to enforce the agreement, they may enforce the rest of it without that illegal provision, or they may limit the application in that provision. So essentially take their blue pen and line out the illegal parts of that lease and leave the rest, if that's what justice requires. Another one that this would be in an employment agreement, where maybe you have a non-compete agreement. It's fairly common to see a clause like this that says, okay, we are agreeing that we think this non-compete provision is reasonable, but if a court thinks it isn't, we are asking sort of preemptively that they not just throw out the whole employment agreement, but that they reform this to what is reasonable. So if it's a 100-mile radius and the court thinks that's too much, let them put in what the geography should be. Okay? So that is Contracts 2, done for the day, and we'll come back next time and do some more exciting things with the UCC.